Good afternoon, everybody. My name is Haitham Amin. I go by Sam. I'm an attorney here in San Francisco, California. I'd like to welcome you to my YouTube channel. Today we will be discussing Penal Code Section 245A1, famously known as assault with a deadly weapon. Before we jump into the discussion today, I'd like to invite you, if you have not already done so, to please subscribe to my channel. Of course, like, comment, share. Follow me on my other social media platform, Instagram, Facebook, TikTok. Now, back to Penal Code Section 245A1, famously known again as assault with a deadly weapon. And I'd like to start by giving you an example, as I usually do, of things that I have seen in my practice. In this instant, I have a client who was arrested for fighting over a parking spot where him and another group of people thought they were entitled to the same parking spot. Long story short, my client was found himself rather in a shouting match with a group of 4 men while he was alone, or rather with his family, but alone on face to face with these people, with these a group of 4 men. And he was in a situation where he had to pull out what he thought was appropriate and necessary at the moment, a metal wrench, just a wrench that would use to rotate tires or unscrew the tires rather. There were the eventual matching then turned into physical altercation where my client got sucker punched. Then he ended up using the metal wrench and hitting one of the guys over the head, sending one of them into the hospital requiring stitches, and also that person suffered concussion. Now, in order for the DA's office to succeed in convicting my client, they'd have to prove a number of elements. First, they have to prove that touching is harmful or offensive. In this case, they're going to argue that my client, by virtue of hitting somebody over the head with a metal wrench, is sufficient to satisfy the harmful touching element. Now, the second element the DA would have to prove is that the weapon, or rather the item or the wrench that was used, it was enough to produce great bodily injury or even death, or likely to produce GBI, great bodily injury or death. It doesn't actually have to produce an injury. So if my client just brandished the metal wrench without actually using it by hitting this person over the head, he could still be charged with an assault with a deadly weapon. In this instant, my client did use it, so the second element would be satisfied. Now, the other important element the DA would have to prove is my client's conduct was done willfully. Willfully does not mean he has to intend to break the law, but rather he hit this person purposefully, with the purpose to injure this person, or with the purpose to attempt to injure this person. Whether or not he succeeds again at hurting somebody is not important for Penal Code 245A1. Now, we anticipate arguing that my client was involved, or rather engaged in self-defense of himself and others. Again, he was by himself outside the vehicle while his pregnant wife was in the passenger seat and his 2 toddlers were in the car seats. So my client was outside and he was surrounded by 4 adults, and they were shouting at him back and forth, and at that point my client felt that he was in imminent danger and he was only able to protect himself and his family by pulling out a metal wrench from his trunk. Now, in order for us to succeed at a self-defense argument, we have to prove that, again, the danger was imminent, the force was necessary to stop that danger, and the force was appropriate under the circumstances. So, imminent in the sense he was surrounded by 4 people, and these 4 people, one of them ended up punching him on the side of his head, and he only at that time felt he was able to dispel that danger by pulling out a metal wrench to try to scare off the attack, and the force was necessary because he was not able to protect himself from being punched further or even beaten to by a group of men without having this metal wrench to try to protect himself and his family as well. His family was also watching this attack unfold, so it was definitely traumatizing for the wife who's pregnant and the 2 toddlers in the vehicle. We also have to show that the level of attack or self-defense was appropriate under the circumstances. Now, that's a reasonableness utility test that would have to be decided by the fact finders, whether it's the judge or the jury. Hopefully the DA is reasonable enough to put himself in my client's place or shoe, or imagine himself being outside protecting his pregnant wife with 2 kids or 2 toddlers in the back seat, and one of the 4 men punches him, and he finds himself in a position where he has to protect himself. He pulls out a metal wrench, and in my opinion, that's reasonable force, considering there's, again, 4 adults against 1 person. With that being said, if we are not able to get this case dismissed, I look forward to litigating this case before 12 jurors of my clients, peers of my clients, or peers of his community rather, and I'm confident that we'd be able to get this case thrown out, or hopefully, again, short of trial, dismissed. If not, we'll litigate it, and I'm sure that we'll be able to convince reasonable people of my client's conduct under that circumstance. I'd like to thank you for spending a few minutes with me. As always, if you have not already done so, please subscribe to my channel, comment, like, share. If you have any specific questions, you can send me a DM or you can write them in the comment section. I'm always happy to get back to you either at my next video opportunity or just writing you a message back. Thank you and have a nice day. Being the only person that's advocating in the courtroom on behalf of the accused is a humbling feeling for me. I believe in the tenets of the Constitution, which is innocent until proven guilty, and that carries from day one until the trial date.